people that if you, as you're speaking, even though sometimes your names are there, if you would identify yourself for the recording, it will help Chris a lot. Is that correct, Chris? Unmute yourself, Chris, so you can talk for a minute.
Including
Yes, I
as well.
need people to identify themselves.
Yeah, people to identify themselves.
I'm busy and my eyes are down normally.
Yeah, your eyes are down. So I will, when I'm dealing with the board, Chris, I'll just call on them so that you'll know. But if it's people from the public, I will ask them to identify themselves. And people keep me honest so that I make sure that I do that. And I will try to monitor who's waiting, Chris, so that you don't have to deal with that.
Okay.
I will monitor the participants and admit people as we go forward. And I'm going to go ahead and call then the first case, which is 1213 Cumberland Farms Incorporated, appeal from person aggrieved, appeal of the
That would be, pardon me, Sharon, that'd be 2013.
Oh, 2013. Okay, I thought so. 2013. Your computer wanted to do 12s instead of 20s. It was a better year anyway, so that's all right. Appeal from a person aggrieved, appeal of the building inspector's August 3rd, 2020 denial of CFI's application for sign permit in connection with replacement of a tenant's freestanding sign located at 2485 State Highway. And the board for this will be Mick, Manny, Trevor, Will, and myself. And I'm not sure who's speaking for Cumberland Farms, but whoever you are, you're on, and please identify yourself.
Sharon, I think you only listed 4 people on the board instead of 5.
I thought Mick, Manny, myself, Trevor, and Will. Yeah. I think that's 5, right?
I think you listed me off for that. Okay.
All right.
Great. Hi, Doug Troyer on behalf of Cumberland Farms. I'm listed as Moriarty Troyer Malloy on Zoom. Hope everyone is doing well and healthy and safe. So tonight, Cumberland Farms has brought a appeal of the building inspector's denial of our sign plan application for a replacement freestanding sign on this property located at 2586 State Highway, Route 6, Wellfleet. As this board is, I'm sure, aware, in our original application for special permits concerning the project to raise and rebuild a convenience store and gas operation at the subject property, Cumberland sought to install a new freestanding sign for its Cumberland Farms operations and also sought to relocate the existing liquor store tenant's freestanding sign further back on Route 6. Cumberland commenced the construction of the project earlier this year, and in connection with the tenant's existing freestanding sign, the project originally called for the continued use and relocation of it. But if I could share my screen. I don't think you'd be able. I don't think you're able to do that. Okay, if I'm not able to do that, it's in my package. Exhibit E of my pack, or actually Exhibit F of my package, kind of shows the existing tenant's freestanding sign. And when we went to relocate it, it kind of fell apart on us. And Exhibit F kind of identifies what that was. The tenant's freestanding sign was a single pole with a sign area totaling 42 square feet. As you can see, when we tried to relocate it, it can no longer be utilized. So as a result of that, back in March, we filed a sign permit application seeking to replace the old sign with a new 12-foot double pole freestanding sign with a sign area of 42 square feet. In essence, trying to go like for like. Pursuant to conversations with Justin Post, the former building inspector, he raised the issue of the height and the ability for Cumberland Farms to replace the tenant's freestanding sign. As a result of those conversations, we revised our sign plan application to bring the height down to 10 feet and reduced the sign area to be 36 square feet to comply with section 7.63 of the bylaw. On August 3rd, the former building inspector denied our revised applications. And I think at the end of the day, I think it's out of abundance of caution, given the history of this case and given where we've been and where we are now. It was proposed to me to let's go before the Zoning Board of Appeals to make sure we dot our I's and cross our T's if there's no issues. it was our argument at the time that zoning relief is not necessary, as the special permits issued for this project permitted a freestanding sign to be relocated on the site. And due to the fact that the existing sign, which was to be relocated, became rotted and no longer usable, we really sought to replace the existing tenant's freestanding sign with a sign that is smaller in sign area and architecturally consistent with the Cumberland Farms freestanding sign that was put up in connection with the project. It's also Cumberland Farms' position that zoning relief is not necessary as the project is grandfathered, but even if we use the current sign bylaws, which were revised in 2017 after our initial application, 7.6 of the bylaw allows for a business on a premises having a frontage of Route 6, and which is located in a commercial district, which we are, to be able to have an aggregate total of 64 square feet plus 9 square feet for a total of 73 square feet of sign area. Given that Cumberland Farms' proposed freestanding sign for the tenant will be 10 feet tall and consistent with the height requirements and a total of 36 square feet, it's Cumberland Farms' position that the sign permit should be granted as a matter of right by the building inspector, and that his denial was inappropriate. In order to further make a request if this board finds that we actually do need zoning relief, this is an application requesting that the ZBA grant Cumberland Farms' request for a sign permit and grant any necessary waivers based on the facts of this case. As discussed previously, and due to the length of time it took for us to get to construction, it was just not known until we started construction that that freestanding sign would have rotted to the point that it has. We're merely looking to replace that freestanding sign with a consistent sign that is very similar to the freestanding sign that we have for the Cumberland Farms operations, with a sign that is architecturally consistent with that. And it's our position it does comply with bylaws. But if relief is necessary, we're respectfully requesting that that relief be granted by this board. I have Don Johnson with me from Cumberland Farms to answer any questions this board may have. And I appreciate your time. And again, I hope everyone's doing well.
And Chris, do we have any letters on this one?
We had no letters.
Okay. And I think I need to ask if anyone in the audience would like to speak to this before I go to the board, right? If you're in the audience and you would like to speak, you need to raise your hand. And I think I will be able to see you raising your hand on this if you are. And I can call on you. All right. Seeing none, I am going to go to the board, and I believe I will start with Manny.
I don't have any comment at this point. What I'd like to know is if Caroline can give us any kind of input on this.
Okay. All right. I think that is a good idea. Carolyn, can you explain to us what's going on here?
Certainly, Madam Chair. For the record, Carolyn Murray from KP Law's Town Council. I had some conversation with your former building inspector back in July or August, I guess, on the sign. And one of the questions that we had to do with whether or not this particular sign was indeed something that was covered by the board's prior special permit decision. And I do note that the decision mentions a pole location elevation or sign pole location elevation. And I had asked the building inspector at that time, I said, can you show me where the existing signs were either mentioned in the prior decision? So I had a copy of the decision, which, on remand from the land court really doesn't get into much detail about signage. So I asked him what, if anything, was shown on the plans. And it was at least represented to me at the time that there was nothing on indicated on the plans. I do note that the applicant has referred us to a 2012 plan in the packet. It may be that my copy is just so reduced that maybe I can't see the reference to the signs there, but I do have a question as to where the sign happens to be. I think the other So the first question I think that the building inspector really had was whether or not any of the prior special permits from the zoning board actually did specifically address the tenant sign, not the Cumberland Farms sign, but the tenant sign. And he could not definitively say yes to that.
Right.
And then if that was the case, then the current bylaw would apply. And then it was a matter of course, the sign of the size of the sign at the time would then have been too large. I recognize that the applicant has now since reduced the size of the signs of this additional sign, but still the question becomes whether or not this is in the aggregate. Does it exceed what is allowed? As I said, your prior decisions didn't really elaborate much on the signs that were there at the time, signs that were included as part of the special permit. Perhaps there's some members of this board who have better memories of that whole process and can shed some light on it. But I don't see anything explicitly in the decision itself, and I don't see anything explicitly noted on the plan that's provided in the packet. So that might be sort of initial question we could explore with the applicant.
Right. I do not remember anything about the tenant sign. Mick, do you remember anything about?
No, it was never mentioned. It never came up throughout the whole process. There was no mention of the tenant sign.
I never heard anything myself. I don't think so.
No. Trevor, do you have any?
Not that I can recall.
No, I don't think we'll. Retha, do you have?
I definitely
No. Yeah.
Now-
My sign expert is Jan. I'd like her to weigh in on signs since she's from the planning board in the past.
And I should note, I don't think it makes a difference, but I was on the planning board in 2011 when Cumberland Farms came before us as a development of significant impact. Well, if indeed it does have to meet current sign bylaws, I would say to you that it does not. And I would draw everybody's attention to 7.2.2, which is the definition of sign area, which says that the area within a single sign area is the area within a single rectangle enclosing all display area of the signs, including borders, frames, structural members, and without deduction for open space or other irregularities. And the area is determined by multiplying extreme width by extreme height above the lowest 3 feet of the supports. So you have to start measuring 3 feet above the ground up. And you have to measure the supports, which are a foot wide on either side. So even if it has to meet current sign regulations, it doesn't.
Right. Okay. Will, do you have anything you'd like to add?
Well, I guess if we could have an explanation from Carolyn on grandfathering. I used to know a lot about grandfathering under New Hampshire law, but I know nothing about grandfathering under Massachusetts statute. So if
Certainly.
she could perhaps shed some light on that, that'd be great.
Certainly. So under Chapter 48, Section 6, a change in a bylaw is not going to apply to any sort of lawfully existing structure or use. And it's not going to apply to a lawfully existing structure or use that has begun, or in this case, to a special permit that was issued before the first publication of the public hearing notice on that amendment. So here we're talking about the 2017 zoning bylaw amendments and whether relative to signs and whether or not that would apply. So one of the reasons I was asking about whether or not the board's special permit decision, whether it was intended to encapsulate the tenant sign in this case, would be that if that prior decision did address the tenant sign, then there would be an argument here that the sign is potentially grandfathered by virtue of being covered under that prior special permit. But I also note that the grandfathering statute goes on to say that although the new bylaw restriction may not apply to a sign subject to a special permit that's already been issued, it does apply to any substantial change, either under the special permit or of the structural change or any kind of alteration after the bylaw has been adopted. So I don't have any information that tells us. I think we need a couple of things. One, what exactly were the dimensions and the locations of the tenant sign back at the time of the special permit? And if we could, again, identify whether or not there is something that links the tenant sign in the special permit decision, so we can determine whether or not there might be a grandfathering argument to be made. And if not, then we look at it under the current bylaw and look at the aggregate sign area that would be allowed.
Thank you.
Abby, you heard?
Yes, of course.
Great. So I thought I'd provide some information to some of these questions that are coming up. And
Okay.
I think the first question was whether or not this sign was even addressed in the original application before we went to the land court. And if you look at my package, attachment A, that is the site plan that was at issue before the land court. And as you can see on this, I've highlighted the area where existing sign to remain. That is the tenant's sign. The proposed sign that is identified there is the Cumberland Farms sign, the freestanding sign, which is discussed. The decision basically incorporates these plans into its decision, and I don't think it's a question that the tenant sign was a sign in which was going to be remained and relocated onto the property line. We went before the board back in late last year to modify some of the plans, and the site plan was one of them. And in that hearing, if you look at Exhibit E, this is the modified site plan application, where it basically, the existing sign to be relocated, where in this sign, we actually identify exactly where the tenant sign is going to be relocated.
It's in Exhibit E, you're saying?
Yeah, that's Exhibit
Okay.
E, and that's the current site plan that was modified by this board back in, I want to say, September 25th, 2019, when we came back to make some changes, minor modifications, given the fact that there had been years that had gone by and the types of buildings that Cumberland Farms were making now were a little different, and we made some changes, and this board granted that on September 15th. So that sign that we're talking about, that's identified both on Exhibit A, the original site plan that went up on a land court, and then Exhibit E, which is the revised that was granted by the board, do identify that tenant sign. That tenant sign was 46 square feet of area. We're looking to reduce that. I'm not 100% sure what the height of it was at the time. I think it may have been 12 feet. We're actually looking to reduce it down to 10 feet and reduce it down to 36 square feet, which is a reduction. Additionally, in addressing Ms. Morrissey's comments about referring to section 762, I think that's the section.
No, 7.2.2. 7.2.2. It's the
7.2.2.
the definition of sign area. So that tells you how.
Yeah, I guess I was going off of 763 is what I was referring to. It's our position that we are grandfathered, but at the same time, even if we're not, I believe that given the fact that we were permitted to basically relocate this tenant sign and are seeking to provide a sign that, in our opinion, is in compliance with the zoning bylaw, that we do not need zoning relief, but in the connection, if you are in fact correct that we are in an aggregate over the allowable sign area, we have a 36 square foot sign on the Cumberland Farms operations that I believe is 10 feet high as well. We're just looking to mirror that with a much smaller sign of area than what we would have been able to do if that tenant sign would have been able to be relocated.
Okay. All right.
Oh, and also in connection with the substantial change, I believe that that provision will not come into play because we are not seeking an increase in what that tenant sign is. We're actually looking for a decrease. So it wouldn't necessarily be a substantial change. It would actually be a reduction in what we would have been permitted to relocate that sign if it just hadn't rotted. And to be honest, I think even at the end of the day, I believe that the site is a much more attractive site, and I think having a more consistent sign there that is consistent with the other signs just on the property instead of relocating it is in the best interest of the neighborhood and the community.
Okay, and Janet, I think I saw your hand.
Madam Chairman, through you, maybe Carolyn could address this. If the special permit, the original special permit, granted them the right to relocate the original tenant sign, once it's rotten and can't be used, in my mind, that becomes a replacement sign or a new sign, which then it would have to comply to the new sign bylaw because it's a new sign, a replacement sign. Am I off base with that?
You are not off base with that, and I'm actually flipping through my bylaw to try to find the provision that Justin and I were.
7.3.7.
Well, that addresses a non-conforming sign, but I thought there was also something. So but that would allow the non-conforming sign, assuming the prior sign was non-conforming, would allow it to be replaced and reconstructed.
No.
It's not questioning whether it has to be replaced or reconstructed, just that the sign bylaw is meant to address replacement or new signs. It says that in the first paragraph, objectives, 7.1. So is this a new, or well, is this not a replacement sign? Which means
I think it could be considered, yes, a replacement sign. What I don't know, however, I mean, with respect to 7.3.7, was the prior sign considered non-conforming?
No, I don't think so.
Yeah, I don't know that.
No, I don't think it was non-conforming. I think it was under the old bylaw and therefore was not non-conforming.
You know, it would make sense to me, just thinking about replacing a sign. If you had a sign that was grandfathered, let's say, and a semi came by and just ripped it out of the ground, it was gone. It was even the foundation of the sign, it was gone. I think a store owner would have a right to put in their sign again. Would they not? I mean, the fact that the sign is gone, at least to my mind, it's not logical that you would lose your right to replace a sign. Now, that's not exactly what happened here, but it's sort of akin.
Except in this case, it was a brand new construction.
Exactly.
And so since it was a brand new construction, I have the feeling that, I mean, this board has been very tough with a number of client, cases recently on signs and on following the sign bylaw. And so if this had never existed and they were coming in with a request for this size sign, we would be following the bylaw as we did with the other two cases on Route 6 that we have recently heard. So it wasn't an act of God or semi in this case. It was choice to reconstruct the site.
Yeah.
I throw that out.
Yeah, if I may, Madam Chairperson.
Certainly.
Yeah, we have been very, very hard on people who wanted to do bigger signs because of the new sign bylaw. And I believe that with the intention of redeveloping the whole site, that this should fall under a new permit for a new sign. I just don't feel that it should be grandfathered in, because the building, there's nothing left of the original building that was there. It's completely gone. This is, as far as it's a brand new building. So that's my take on it.
All right, I think I have a request from someone in the audience. So I can go ahead and let you, go ahead, Frank. You can unmute yourself and speak for a minute.
Hi, my name is Frank Corbin. I'm here with my wife Denise, and we're the nearest residential abutters to Cumberland Farms. I could walk outside with my iPad and show you it's lit up like a Christmas tree right now, and will be for the rest of the winter. You can't even see the night sky. The original liquor store sign was a batter board sign with two floodlights on it, one facing north and the other south. So now we're talking about a sign that doesn't meet the square footage of the sign code. And I'd like to see the signs be smaller. If they want to add a liquor store sign, then reduce the square footage of the Cumberland Farms sign so that both signs meet the code. That's all I have to say, but my wife might.
I had questions with regard. Cumberland Farms had tried to put a question on the 2020 ballot regarding beer and wine sales. They withdrew this in June, but their intention is to go forward in 2022. Now, if this sign for a liquor store, they want to change everything so that they want to increase the numbers of liquor licenses. So instead of them only having, like, say 9 in the state, they could have them in every one of their stores. If another sign is allowed for this liquor store right now, does that mean that Cumberland Farms ends up with 2 signs on the property? One of them advertising their store and their gas prices, and another one, which I'm sure they'll be taking over because they'll be wanting to sell the beer and wine themselves. So I'm wondering about the precedent that having another sign might set.
Okay, thank you.
Thank you.
Mm-hmm. Okay, I get, who else have I not heard from? Retha?
Really don't have any questions at the moment.
Okay, all right. Trevor, do you have any more on this one?
I don't have any questions at the moment, but I'm currently inclined to agree with Mick's position that because of the extent of, I mean, they completely redeveloped this property, every square inch of it. And so I tend to agree that it seems like they've gotten to a point where things should be brought into compliance.
Okay. Anyone else? Manny? Will?
No,
If I may, Madam Chair.
Yes.
Hi. So we have submitted a new application for sign. That's what is before you. And there has not been an indication from the building inspector that what we have submitted is in fact in violation of the zoning bylaw. My understanding is that the sign that we have proposed is in compliance with your zoning bylaw. It is 36 square feet. It is 10 feet high. We are permitted to have, because we have multiple businesses on the site pursuant to 7.3.4, we are permitted to have an additional freestanding sign. We were originally, if this was not something in which was originally permitted or sought for permitting, I would understand the board's position that we would need to start from scratch and basically ask for the ability to put a freestanding sign on. What we have here is a permit that was granted specifically on the plans that were granted and incorporated in a decision, there was to keep the existing liquor store sign. In September of 2019, we came before the board with a modification request where you granted the modification request of the new site plan that shows the relocation of that sign. We have the ability to put the sign there, and I'm willing to hear from the board as to if there is a violation of the bylaws as to the size of what we're doing, then yeah, I think that's something in which we can discuss, but I'm not hearing that. What I'm hearing is the inability for Cumberland Farms to basically install this sign because it's just now coming up. It was part of our project. It was permitted. We have the ability to install a freestanding sign, and I believe that the whole question that Mr. Post had, and maybe Carolyn could correct me if I'm wrong, was that given the fact that that sign had been destroyed, was there any legal consequences of Cumberland Farms' ability to replace a sign? And I don't believe that that's the case. I think we have the legal right to do so. We have so under your bylaws. And if it's a question of the size of the sign, then that I would like to hear, and that there's definitely conversations that can be had about whether or not, if we're in violation, what then do we need to do in order to bring a sign that is as of right.
Okay, couple of things. First of all, what we are hearing tonight is your appeal of Justin's denial. We are not hearing an application for a sign.
That's what the appeal is.
The appeal is
of his denial of my sign plan.
his denial. Secondly, what you are hearing is that yes, 36 square feet is the size that you are legally allowed to have under the new bylaw. But your sign isn't 36 square feet. It isn't measured right.
Then enlighten me, please. I would love to rectify that.
Janet, you're better at this than I am, so please enlighten him as to the size.
I'm going to repeat that you need to read under the definitions 7.2.2 sign area. That's how you measure the area of a sign. So anytime you see sign area, that you got to refer back to the definition. I think that you just overlooked the definition. 7.2.2.
7.2.2.
7.2.2. In the definition section of signs, the sign bylaw.
I'm looking at the wrong sign bylaw. I apologize. Don Johnson, do you have any information on how we calculated the size of the sign?
Yes. Can you hear me? Okay. Thank you. My name is Dawn Johnson with Cumberland Farms. It's under D. Johnson, as you appear on the screen. We calculated the sign just based on the face of the sign. We did not include any of the support beams. If that is how it is truly supposed to be calculated, we did not do that. We just calculated the overall face of the overall square of the sign, 6 by 6.
Right.
That does not include the 1 foot posts on either side.
Or the 7 feet of height above the first 3 feet. You have to count that too.
Correct. We did not count any of that. And I would just like to also add is that the only reason that the existing tenant sign is even up for discussion is because whenever we purchased this property many years ago, the tenant sign was already there, and it was built so that half the sign face was over the property line into the DOT right-of-way. Had this sign been built correctly and completely within Cumberland Farms property, then that existing, I think it was actually 15 feet high, and it was 42 square feet. It was 7 feet tall by 6 feet wide, would still be standing there today.
Okay, so I think that the question we have here is that yes, in fact, a 36 square foot sign is is allowed under the bylaw. It is allowed for the tenant. It is not, does not, I don't think, affect what the current Cumberland Farms signs on the property. The problem is that this tenant sign needs to be measured and sized such that it is in fact meeting the sign definition bylaw and not bigger. Does that make sense?
No, that makes sense. That makes sense if in fact the 2017 bylaw is applicable to us, which we disagree with. We're merely hoping to take a bad situation with the sign that was in deplorable condition and rotted out and replace it with a smaller sign, to which we have a right to do. I'm trying to avoid further issues with this and taking certain positions to basically prolong this. I feel like Cumberland's position is fair and reasonable. I think Cumberland is not looking to put a 15-foot sign with 46 square foot area on it. We're trying to basically put in a similar sign to what we already have there to be consistently and aesthetically pleasing to the site. So if the board doesn't believe that if the board finds that we are required by the 2017 bylaw to proceed, then I guess it's up to Cumberland Farms to make a determination as to whether or not it wishes to revise its sign plan application and file saying with the board. I don't think the board is saying that we're not allowed to replace that sign. No. That would be a different situation altogether. And unfortunately, the building inspector did not identify to us these issues in his denial. These are new issues in which have been brought to our attention, which is unfortunate. It's something in which we probably could have addressed months ago, but it is what it is. We were hopeful that the board would find that what Cumberland Farms was looking to do, and given the fact that the project has been built, and I think it is a much better and aesthetically pleasing project on the site today, that there would be, given the situation, given the facts, and given the of this case, and given the fact that we were looking to put in a smaller sign than what would have been there if it would have stayed, that we would be able to get some waivers from this, if in fact the board finds that we are subject to the revised bylaw. But that's basically the whole purpose of this at this point.
Now, can I ask you a question again? What's your position on why your client's not subject to the 2017 bylaw?
Because we originally filed our application back in 2011. It was subject to an appeal, as everyone knows. That appeal went to the land court, basically up until, and then went up to the appeals court. In 2017, this board granted a special permit decision. In 2019, when Cumberland Farms was looking to start construction, and given the length of time, we appeared before this board in September of 2019 to modify certain minor modifications to the site to kind of conform with existing conditions. That was granted. At all times of this project, that tenant sign has been part of this project. From the tone of this meeting, it's like this tenant sign was brand new issue. It's never been discussed. It's never part of the project. This is not a new sign. This is a replacement sign to which we have the ability and had the ability to put. We just had an issue of it rotting and falling apart. And we believe that what we have proposed is consistent and is less non-conforming than what was originally there. And if it is an issue to determine whether or not this conforming sign at the time, that's something we can look at, and I can make an argument that it's a non-conforming, it was a non-conforming sign, and we're actually looking to be a less non-conforming, which I believe I would have a good argument for a non-conforming finding with. But the last thing any of us want to do is prolong and get into another legal battle on this site. That's the whole reason why we were attempting to basically reduce what that tenant sign was and bring a sign that's consistent to what's already on the property.
Thank you.
Carolyn, I have a question for you, which is that assuming that the sign becomes smaller and is in fact 36 square feet, my understanding is they don't need to come to us for that.
I would agree with that, Madam Chair.
Right. So basically that's, I mean, our issue here is that this sign doesn't meet the bylaw. If you have a sign that does meet the bylaw, then we're done. And the building inspector would have, in fact, granted the permit, and we wouldn't be involved in this.
Well, the building inspector didn't deny the permit based on the size of the sign. He denied it based on the fact that he was wanting to dot his I's and cross his T's given the history of this.
Well, I don't know.
The reason
I
we're
don't know
here
what
is because of that.
Madam
Not because I've been informed that it's in violation.
That's incorrect. That's incorrect on the building inspector. Crossing his T's and dotting his I's. He's just upholding the bylaw as he understood it.
No, and I respect Justin a lot, and I think he did a great job for you guys. All I'm saying is this is the first time I've heard that our proposed sign is in violation of the existing
We've had a lot of
bylaw.
problems with signs in Wellfleet, so it's.
I understand. No, I understand.
He's not picking on Cumberland Farms in any way, shape, or form. So,
Madam Chairwoman.
Yes.
This is Ben Zender, and I don't represent anybody in this case, but I can't not chime in on this. The SJC a long time ago in 1995 decided and determined that signs are structures and uses protected by General Laws Chapter 40A. So if in fact Cumberland Farms had a sign that was in place prior to the adoption of the new bylaw, and even if it was removed in connection with a construction, but they didn't intend to abandon it, it's a non-conforming sign that they have a right to have. So I think Justin made a mistake here. I don't think that Cumberland Farms has to comply with a new sign bylaw for a sign that existed prior to the adoption of the new sign bylaw. It's like a structure, a deck, a house. It's like anything else. So
Except that it's fallen apart, Ben.
Well, but things
so it doesn't
apart.
exist.
They do fall apart, but then
they're not grandfathered.
Well, no. The question for the board then is whether or not the applicant intended to abandon their rights in that sign, and they were in the middle of a construction process. If this board finds that they intended to abandon their rights, obviously, but I think that would be a tough lift given the environment of this particular permitting construction project. So that's my 2 cents.
Madam Chairperson, so
yes.
what we're hearing right now is we're hearing the denial of the sign that the building inspector gave, right?
Right.
So
that is what we are hearing.
Okay. So we've gone around in circles 5 or 6 times now. So can we bring this to a conclusion of some form or other?
Yeah, what I am hearing, what we have before us is, do we uphold the building inspector's denial? That is what we are hearing right now. Do we uphold the building inspector's denial? If we read the bylaw the way we've read the bylaw, do we agree that the building inspector was correct to deny this permit?
Okay. So are you polling the board right now?
I guess I'm polling the board, yeah.
Shouldn't Caroline give us some guidance on this?
Sure.
No, I mean, that's why she's there.
That's why she's there. Okay, very good. Carolyn, can you give us some guidance on this?
So to the extent that I can, now looking, just going back to the original permit, the original special permit in 2017.
Yeah.
I can now see, thanks to the assistance of Doug pointing some things out, I can now see on the sign or on the 2012 plan, I can see references to a proposed sign and then something else that looks like it says existing sign. I can't tell what those signs are, however. Reading one as a proposed sign and another as an existing sign, it seems as though we are moving one to the proposed sign location. I also note that now I don't have the prior history and recollection as to exactly what was there previously. I know we had Cumberland Farms and we had a liquor store. I don't know all of the signage that was associated with those two uses previously. So I've got to defer somewhat to the board as to what you recall. But looking at the application and the narrative that the applicant has submitted, it appears there were actually two signs that we're talking about here. One was a Cumberland Farms sign and a different freestanding sign for the liquor store.
Yes.
So again, I go back to the 2012 plan, and I see a proposed sign, which would be a new sign. I see a reference to an existing sign. That to me is we have one existing sign and we have one proposed sign. I don't see two signs, but perhaps that could be pointed out to me. Be that as it may, I'm not hearing the board say that the additional sign couldn't be allowed for the liquor store. I don't disagree either with what Mr. Zender has said in terms of there being, a status that is conferred upon signs as structures. I don't think this is necessarily a situation of an abandonment where a sign has just deteriorated over time. Mm-hmm. What I don't see really in the application is the prior comparison and the current comparison. So in terms of how many signs were there previously, mm-hmm. Were they roof signs? Were they freestanding signs? Were they ground signs? Were they mounted to the side of a building? And what was the square footage and the aggregate square footage of all of these signs? But again, the board, I can't speak to everything that went into the building inspector's denial. I've read it as you have, and there is not much information there. The board certainly would be well within your rights based on your own knowledge and memories of the site as it existed. You know, do you think that this is in keeping with what was there previously and in keeping with what the board approved in 2017?
And Ms. Murray, just the Exhibit A to the package where you're referring to the proposed sign, that is the Cumberland Farms operation sign, just for the record. That's the one that's been constructed. The other sign is existing sign to remain. That is the tenant sign. So it was to remain at that point. That's basically what the original application sought, was to keep the tenant sign that is located there and highlighted. And then they were proposing the Cumberland Farms operation sign. So in fact, there are two signs that were discussed and permitted.
Okay, well, I appreciate that, because as I said, on my reduced and very blurred copy, it was not clear what that said. So I will just also note for the board that, you know, going back to your 2017 decision after remand, your decision did include the referenced and incorporation by reference, the plan submitted, including pole sign elevation plan dated October 20th of 2011. Now, if that is what this Exhibit A is supposed to be, and it's got a different name and a different date, but perhaps it's just a difference between what it was referred to in the decision versus what it actually was, then I think it is, I think the board could find that both of those signs were part of what the board reviewed in 2017 and approved.
Okay. Except that we had no dimensions of any of them at that time.
But the facts are that the sign, the tenant sign, was 15 feet tall, 46 square feet.
Right.
That's what's in, that's before you now.
That was what existed.
And the sign that we're looking to replace it with is 10 foot, 36 feet.
Okay. 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 All right, Manny, does that answer your question about anything?
Well, not really. It still is. We have the plan that we approve, and it mentions where the sign would be, but not the square footage.
Right.
But if what Caroline, I believe that's what she says, that the old sign, the square footage of that sign would be still permitted. Is that correct?
That's correct.
So what I'm seeing here is that we are getting a sign that's reduced, and even in size and also in height. I have a question about the size of the Cumberland Farm sign that's there now. Would it be the same as that, the same size?
Don, I'm going to need you to answer that. I think the
Yep.
question is, go ahead.
Yeah, so the Cumberland Farm sign that is up today is 12 feet high and 41 square feet.
So this would
So
be
the
smaller.
liquor store sign would be reduced to 10 feet in height. Am I correct?
Yes.
That is correct.
And then the sign would be 40 what square feet?
The tenant sign is 36 square feet. Our Cumberland Farms is 41, so that's it's 5 square feet less.
So according to Carolyn, we could give them this special permit instead of having this go to higher courts and a battle for the town again. I don't know what everybody else thinks.
We could, except that I don't know. I mean, again, the case before us is the building inspector's denial.
Yeah.
So we're not actually issuing a permit.
No, it's the denial of his.
Madam Chair, if I may.
Yes.
If you disagree with the building inspector and
Yes.
you ultimately find that for whatever reason you just think his decision was an error, then in overturning the building inspector, if what you are also finding is that the replacement of this sign is something that was in fact covered under your 2017 special permit decision, I don't think there's anything more that needs to be done. They don't have to come back before the board. The board doesn't have to issue a further permit.
Right, that's what I thought.
Certainly needs a building permit.
It needs a
Certainly does
building
need-
permit.
Yeah, exactly.
Right. But we aren't creating a whole new category here for people who have a special kind of sign. We are simply saying that they were covered under the 2017 and therefore should not have been denied.
I think that's a fair way to put it, Madam Chair.
Okay. All right. Okay. So I got to know where my board is here.
I've got a quick question, if I may.
Yes, of course not.
To Ms. Morrissey, on the dimensions that Cumberland Farms are giving us, are their internal dimensions? They're not the external dimensions of a sign as defined under the bylaw, the current bylaw?
But if you're saying that they don't have to meet the new bylaw, then it doesn't matter.
Well, what I'm saying is the 36 square feet that they're saying their sign is the internal dimensions of the sign. It's not the overall sign itself.
It's more like 56 square feet if you measure it by the
Exactly, yeah. Well, would it be possible for Cumberland Farms to just downsize it down to 36 square feet and then everybody's happy?
Except for them.
Yeah, well, you know, they've been, I don't like the idea either on the zoning board that we have a massive corporation and they're saying, you know, we don't want to spend the money going to court. I'm very uncomfortable with that. So we just need to decide whether it's Cumberland Farms or Joe down the road. That's irrelevant. If the sign doesn't conform to the current sign bylaws, then I'm in favor of upholding the denial of the building inspector. That's where I stand on this issue. And let them come back with a sign that applies to the new zoning bylaws of the 27 town bylaws, and let them have the correct dimensions externally, not internally. So it's not a massive sign. It's a 36 square foot sign, not a 56 square foot sign. So according to our rules and regulations, not theirs. So that's where I am on that, Madam Chairperson.
Thank you. Thank you, Mick. Who else? Will?
No, I'm inclined to overturn Justin's decision, and also warn that if Cumberland Farms ends up going to court, they might want the same size sign that was there when it fell apart. So there is some risk. So I am siding with agreeing with the applicant.
Trevor?
Yeah, after hearing all the evidence that's been presented, I am inclined to agree that we should overturn the building inspector's decision. I mean, it sounds to me like we did approve relocation of the original sign, which was much larger. We approved it. We approved that sign twice. We approved it in its previously existing location in the original special permit, and we approved it in its relocated position in 2019. So yes, the sign rotted away, but I think the applicant is perhaps not bringing the new sign into compliance with the current bylaw, but they are bringing it closer into compliance by proposing a reduced size from the original sign that we permitted. So yeah, I'm inclined to want to overturn the building inspector at this point.
Okay. Manny?
I feel the same way. Like I said before, it's a reduced sign. It's going to be a hell of a lot better than having the same size as it was before. So that's all I got.
Okay. Janet?
I'm not voting, so it doesn't matter.
Okay. And Retha?
Agree, whichever, that this is, that it should be allowed. And that means overturning Justin's.
Okay. And that's sort of where I am too. I mean, I think it would have been a nice gesture by Cumberland Farms to actually bring it into compliance. I think in some ways they thought they were and didn't understand how to measure. So they may have made a good faith effort on that. But it is a smaller sign, and I think, it may be time to get this all finished. So Carolyn, I'm not sure what I ask for here in terms of a vote, and what we need to do in terms of documentation for findings.
If I could suggest a motion, and if you think it's appropriate, one of the board members could certainly adopt it. It sounds like an appropriate motion would be a motion to overturn the determination of the building inspector and to find that the tenant sign for the liquor store was included in the 2017 ZBA special permit decision, and that no zoning relief is required.
Okay, now that sounds appropriate to me. I need someone to make that motion.
And if I could also just add to that, Madam Chair, I would also just, for the purposes of the motion, and so that our new building inspector will know, what are the dimensions? So this will be to allow a freestanding sign for the tenant at 10 feet in height and 36 square feet. Is that where we've wound up?
It's actually got a foot on either side of it, right? So it's not actually 36 square feet. What is it, Janet? It's
well, you probably want to say that there are 1 foot supports on either side.
Okay.
That are 10 feet in height.
Okay, so 36 square feet of sign area with 1 foot supports on either side.
I will make that motion.
All right, I need a
Manny.
second.
Second that.
And Trevor seconded it, and I need a roll call, and my board is Manny. You need to, I need a
Well-
voice vote, Manny. So
Aye.
Will,
Aye.
Trevor,
Aye.
Mick,
No.
and Sharon, aye. All right, passes 4-1.
Thank you very much. Have a good
Thank
evening.
you.
Thank
Bye
you.
now.
Carolyn, Chris, will you make sure that Chris has the wording of the motion?
Sure, I'll email it to her. How's that?
Great, that would be great. Thank you
Okay,
very much.
great.
Then we'll have that. Okay, all right.
All right.
Thank you
Good
very
night.
much, Carolyn. Thank you very much,
Thank you.
Jonathan.
Thank you.
All right, folks.
Okay.
Have a good night.
Thank you. You too.
Okay.
Take care.
All right. Moving on then. We are moving to 2011. Harold McGinn and Julia Pestkukis, 2318 State Highway. Application for a special permit to allow 2 principal buildings on the same lot. And my board for this was Trevor, Will, Manny, Mick, and myself. And I'm not sure who's on for this one.
Good evening, Madam Chair. Jamie Norcross, and
Hi,
I'm
Jamie.
representing the McGinn family. How are you
Yes.
this evening?
Good. How are you?
Very well, thank you. I believe Dennis McGinn is also on the Zoom call as well tonight. There's Dennis. As you heard, we're applying for a special permit for 2 principal buildings on the same lot. The property consists currently of 2 separate lots that have been used by the McGinn family since 1974 for their operation of their business, Easy Dozit Construction. Located on the property is a single-family house and office, and previously a garage for storing some of the company's vehicles. In 2019, the garage located at the property was destroyed by a fire. Initially, the McGinns were going to rebuild the garage into its prior location along the northerly property line, but the abutter along that property line raised concerns with placing the garage back in that location. In deference to their neighbor, the McGinns agreed to relocate the garage by placing it in a location that is basically in the middle of the property, as you see on the site plan that we provided. This seems to be an appropriate location as it places the garage away from the lot lines and limits the visibility of the garage from the abutting properties and Route 6. In working with Justin Post, it was determined that the garage, which would be on currently the second lot, could not be located on the separate lot because there was no frontage, and instead the lots would have to be combined by the recording of an 81X plan. Again, we provided a copy of that proposed plan that we would record if the special permit tonight was granted. The placement of the garage in the combined lot would require a special permit because there would now be 2 principal buildings on the same combined lot. So the need for the special permit before you tonight. The new garage will actually be smaller in size. We provided some elevations of the look of the garage. And as I mentioned, by locating the garage in the middle of the lot, it really minimizes any potential impacts to abutters, and we think is pretty much not visible from Route 6 at all. If the board would like, I'm happy to run through the criteria for the special permit.
No, I don't think you need to do that.
Okay.
I think we've all been out to the site as well. So I guess I would just ask Christine if there are letters or anyone from the audience who wants to speak to this issue before we.
No letters.
No letters, okay. And I don't see any hands in the audience, although they tend to be a little delayed. Okay, so I'm just going to go through the board. Retha, do you have any questions about this for the applicant?
No.
No. Manny?
No, I'm okay with it.
Nick?
Nope.
Trevor?
Have the lots been combined yet?
No.
No, we have not recorded the 81X plan yet. We were waiting until to see if we would receive special permit approval tonight. So if you wanted to make your approval contingent on the recording of the 81X plan, that's certainly appropriate.
I think we would either have to do that or wait and do it the other way around, because it seems like the cart's before the horse here.
Right. I think if your decision said that it was contingent on us, my clients, recording that plan, I think that would cover the board and allow us to move forward at the same time.
Okay. Janet.
I have no questions.
And Will.
No, I'm fine with the proposal and as well granting the approval subject to the merger.
Okay, and I think Ben has his hand up. Ben? Ben, did you mean to speak on this one?
No, I just never took my hand down. I'll do that now.
Okay, and I have no questions on this one either. So
What about Mick? Madam Chair,
I thought I went to Mick, didn't I?
Yeah, I just, so if the board is comfortable with the condition of merging the two properties, it's just something we haven't done before. So I don't know if is it a big ask for the board to approve a special permit where the lots have not been cleared beforehand. I kind of agree with Trevor that we're putting the cart before the horse.
No, can I speak to that, Madam Chair?
Please do, Will.
As a lawyer, you would never want to merge the two lots first, because then if we for some reason denied their request to put the building where it is, they would have greatly prejudiced themselves. So I think in this instance, it's a logical request by the applicant to make the conditions subject to the merger.
You know, at the last meeting, I said the same thing. Having two lots, how can we vote on this?
Yeah.
And when I think Will is the one that, said that we could. And I'm not sure if we should.
I'm with Manny on this one. I understand what you're saying, Will, about if you're a lawyer and you're representing your clients, but in this case, this is the zoning board, and we have never done anything like this before since I've been a member of this board. And we've had people that have asked that question before, and we've asked them to go ahead and merge their properties and then come back and get a permit. So I think it's a big ask. That's what
the thing here, I believe, is that they cannot move forward. If we condition the permit on this, they cannot move forward unless they have met the condition.
Madam Chair, if I may briefly, we wouldn't be able to get a building permit to construct the building until we satisfied the conditions of the special permit. So I don't think the board's prejudiced at all in that regard. The special permit would essentially be moot if we don't satisfy the condition. We never get a building permit.
Right.
Yeah, and just to make it clear, I'm not in favor of the project. It's the procedure that, again, I just think it's a big ask. That's all.
No, I appreciate that. As your fellow board member pointed out, it's a little bit of attorney paranoia that we suffer. But
to be honest with you, that's fine too. I'm a painter. I got painter paranoia, but
the trouble is that if the lots are combined and then we deny the permit, then they have certainly gone to a great deal of financial disadvantage because they can't sell those lots again. So, I mean, in this case, I think, I get why they need this. And I really believe that conditioning a permit protects us in this case from anything. Ben, you had your hand up. Is that what you wanted to say?
Yeah, Madam Chairwoman, I just wanted to, can you hear me okay?
Yep.
I just wanted to say, to address Mick's point, the board has done this before, specifically there was a project on Pilgrim Road where Susan Behan was relocating one structure that was eroding away to another lot, and the board conditioned the approval on her submitting an 81X plan and having that approved by the planning board. And in fact, they did do that. It was approved. So there is a precedent for this. Just if that gives you some comfort, Mick.
Yeah, no, that's fine. People say, well, then they mightn't be able to sell their property later on. Well, doesn't concern the board in any way, shape, or form. But if we're going to put a condition on it, then I guess that allies my concern, but I still think it's a big ask.
Yeah. I think if we were not conditioning it, I would not be comfortable with it either.
Oh,
But
no,
I
no,
do think
me
that,
either.
No, I'm fine with it. I think,
yeah,
you know,
yeah. So
The other advantage is we get it off our calendar. You know?
there's something to be said for that.
And to be fair to the applicant, it saves them a few bucks. You know, why do they have to come back? You know,
Yes, right.
Incur some more
Mm-hmm.
attorney's fee. You know, I know.
Mm-hmm.
hey, that's their choice, though. You know.
Mm-hmm.
Well, yeah, I don't know. It's not much. I mean, I've done that when professionally. I've been doing zoning for 42 years before I showed up here. We did this all the time.
Yeah, that's fine. I'm just saying. I just put. I told you where I stand on it.
That's fine.
Right.
Oh no.
Okay.
No.
All right.
I respect that, Mick. No,
yeah.
no problem.
Are we ready to go to findings on this one?
I will move. You want to move to findings?
Second.
Okay. All right. Here's what I have for you. The lot is in the C2 district. The property includes a single-family dwelling and is the premises for Easy Does It Construction Company. The operation has been in business on this location since 1974. A garage located on the property was lost to a fire in 2019. The applicant proposes to reconstruct the garage. The applicant wishes to relocate the garage structure away from the boundary line of the property. There are currently 2 lots on the property. The applicant proposes to combine the 2 lots into one and is asking for a permit to allow a second structure on the same lot under the provisions of Wellfleet Zoning Bylaw 5.4.13. There will be no change or increase in use. The use conforms with the objectives of the C2 district as stated in Wellfleet Zoning Bylaw 3.2. There were no appearances or correspondence either for or against the project. The board has found that pursuant to Wellfleet Zoning Bylaw 8.4.2, the proposed use is compatible with neighboring properties. Roads, drainage, and public services are adequate. The business contributes to the diversity of services in the area. There is no negative seasonal impact as this is a year-round business. The proposed structure is to the rear of the property and will not be visible from the state highway. The proposed second structure will not be more substantially detrimental to the neighborhood than the existing use, and the applicant has demonstrated that the benefits of the proposal will outweigh any adverse effects on the town and the vicinity after considering the district objectives for the district as provided for in Wellfleet Zoning Bylaw 3.2 and the relevant criteria set forth in Wellfleet Zoning Bylaw 8.4.2. That's what I got. Anything else?
I will move to accept the finding of fact.
Okay, and I need a second.
I will second it.
All right, and all in favor, I need Trevor.
Aye.
Will.
Aye.
Manny.
Aye.
Mick.
Aye.
And myself, aye. Okay, then it is subject to the following condition, and help me with the wording on this. This permit will not take effect until the applicant has filed am I calling this an 81X?
That's correct.
An 81X confirming the combination of the 2 lots into one. Do I need to
I will
say?
move to grant the special permit.
I will second it.
All in favor. Trevor.
Aye.
Will.
Aye.
Manny.
Aye.
Nick.
Aye.
And myself, aye. Now you get stamped things, but you have to come by the,
Do we move to accept it?
we just did, didn't we?
Oh, we did.
Yeah, we did.
You moved to that.
That's what you moved, Manny.
Don't confuse me, Manny. It's hard enough.
It's your fault, Will.
My fault.
It's all that lawyer talk, Will.
I'll
Chris,
be quiet.
Chris, what do they do next? Given that there's nobody, I can't hand them anything. What do they do?
What I can do is either send stamp plans along with the decision, or they could stop at the office when I get it typed up after you sign it.
Okay. All right. So Jamie, is that okay with you
Sure.
guys?
I'll email, I can email Chris and we'll coordinate either
Okay,
picking it up or mailing it. We appreciate that. Thank you very much for your time.
Thank you. Okay.
Thank you.
Bye-bye. All right. All right. We're on to 2012. Richard Tout, 3095 Baker Avenue, map 20, parcel 59, application for a special permit under Wellfleet zoning bylaw 6.1.5 and et cetera, to construct a second floor on the pre-existing non-conforming garage for a volumetric increase in the setbacks, continued from last time. And so I believe it is Mr. wherever he is. Where are you, Mr. Hatt? There you are, Mr. Hatt.
Yes.
You're on.
Thank you very much. The owner wishes to increase the second floor space above the garage. The exterior outside walls of the garage on the second floor right now are 4 feet high. He wishes to tear the existing second floor off and rebuild it with 8-foot walls. And the reason for this special permit is because there would be a volumetric increase in the amount of space by increasing the exterior walls from 4 feet to 8 feet. The amount of increase that the new construction adds is about 22% of the garage volume. And when you combine that with the other house on the property, it's about an 11% volume increase in both properties. And we believe that amount of increase is relatively small, and it's not very detrimental to the neighborhood. And we don't think it should be something that the board has any problem with. And in addition to the work that they're doing, the owner has applied for a Title V septic system, a new Title V septic system, which would be a big improvement to the property.
And I neglected to say that the board for this is Will, myself, Trevor, Manny, and Mick. I'm sorry. Okay. And I have one letter from Michael Altman. Richard, dear ZBA, Richard Tout has applied for a special permit to construct a replacement expanded second floor over his existing non-conforming garage. The 3095 Baker property is adjacent to another Tout property whose address is 90 Clark Avenue, 960 square foot. The two properties combined measure 22,400 square feet, 0.5 of an acre. On those two properties are two houses, a large garage, and two sheds. There are therefore a lot of buildings in a small place, and the property is located in a gully, so noise echoes up from the properties. My wife and I own 85 Summit Street, which is adjacent to the Tout properties. I have spoken to Rick Tout about his construction plans. He advises that he intends to expand the second floor of his garage in order to build a recreation room in which his grandchildren can play. I have no objection to an expansion for the purpose stated, so long as the special permit makes clear that the second floor cannot be converted into living space, i.e. there can be no housing, no kitchen or bedrooms allowed in that space. Mr. and Mrs. Tout are both about 80 years of age. I am confident they will use the space as represented. I am concerned, however, that when others inherit or purchase the properties, they may have different ideas or needs. That is why I'm requesting that there be explicit restriction stated of the proper uses of the garage. If the garage were converted into living space, that would mean more people, more cars, and more noise, which would be detrimental to the neighborhood. Thank you for your consideration. Is there anyone else from the audience who would like to speak to this particular project? Seeing no hands, I will go to the board. Will?
Yeah, Mr. Hatt, do you know
Yes.
what your client's position is on the request of Mr. Altman about the restriction on the use of the garage?
The planned use of it is for a rec room. There's no kitchen facilities that are planned for there, and it's not to be used as a bedroom. So if the board wants to put some restrictions on it, I don't think that the owners have any problem with that. The intention is to use it strictly as recreational space.
Okay, good then. Thank you.
Janet?
No, I don't think I have any questions. I'd like to hear what the rest of the board says.
Okay. Retha?
It seems simple, pretty clear.
Manny?
I don't have any problem with it. And I don't think we should put any restrictions on it. The Board of Health can deal with that when they give them a permit. Otherwise, I don't have any other questions. I'm all set.
Nick?
Yeah, I'm the same. I don't have a problem with it. And as regards bedrooms and all of the stuff, that's the Board of Health job, not the zoning board job.
Trevor?
I don't know that I agree with Nick and Manny. I think it's very interesting that in the plans that were submitted to the board, there's no floor plan that shows that proposed space on the second floor. So when I first flipped through this packet before we heard this case the first time last month, my first thought flipping through the paperwork was they're going to turn this into an apartment, or they're going to turn it into some sort of living space. It seems to me that it's a pretty big building that's there, and I understand there's 4-foot walls on the second floor, but the roof is going up from there. And so, unless their grandchildren are all NBA players, it seems like there would be plenty of room for kids to play in that space without making full 8-foot walls on the second floor. So I actually found Mr. Altman's letter to be in line with my thinking that this smells an awful lot to me like something that's going to turn into something else. And I don't know how many people, I assume all of us drove by and looked at the property. It's a pretty dense neighborhood back there. There's a lot of buildings on top of other buildings. And this building is already quite large, and making it that much taller, it's going to feel like a very big building, I think. So I don't know. I'm inclined to think that this might be a bit of an overreach on a small piece of land, which is already pretty well developed. And at the very, very least, I think we need a plan that shows what they're proposing to do up there. And if it's just an open space, then we need a plan of just the open space. And I think it's absolutely appropriate to put conditions on it.
There's a plan here, page 3 of 3, that has that floor plan, and it has a bathroom in it.
I'm sorry. Yes, I see it. Thank you, Manny.
And it even has a fireplace in case your hands get cold. You could warm them up.
I see that now, Manny. Thank you.
But like I'll say it again, if the Board of Health, they have to upgrade their septic system. And the reason I believe is because the Board of Health will count this as a bedroom. So, and that's why I think they have to upgrade unless it's not a Title V.
There wasn't a Title V on the property to begin with. It was a very old septic. So,
right.
In order to do anything, they needed to upgrade the septic system.
Right.
Sharon, can I?
Yes, by all means.
I mean, I agree with Trevor. I mean, I've got a neighbor, and I don't care, but they have a garage, and then they built on the second floor, and then they had a hot plate, and because a friend of mine rented up there, and now not only is it rented in the summertime, it's rented all year round. So it is one big room. So it doesn't take much.
Then I think you should complain to the maybe the building department or the health department.
I like my neighbor. I'm not complaining to anybody, thank you.
But,
yeah, well, that happens, yes.
I'm just commenting on what happened.
How can we say that it's going to turn into a bedroom?
We can just
You
say
know,
this is conditioned on it not being used as a bedroom and no kitchen facilities can be installed. It's simple.
Well,
And then,
I'll say this again.
and the applicant doesn't care, and we meet the concerns of a neighbor. So I think everyone wins.
When you go to get a permit and you give the health department is the first place that you start, and because they're the ones that will tell you if it's a bedroom or not, or if you can get a permit. And I believe if you put if they're counted as a bedroom, and you have to put a septic system in to accommodate that, then why shouldn't you be able to use it as a bedroom?
Well, I don't think the septic system question, as I've read those septic system thing, I think that's already needed, even if they were doing no construction.
Unless it fails.
I think it
not,
has failed.
Because they're what do you call it? Septic systems in the ground now that's been there for 50 years.
Right.
I have clients that have them because they only live there a month or two per year. And they don't have to unless they sold the house or they were going to add on to it, and that would trigger an inspection.
Right.
So anyway.
When was the garage built? Do we know that?
When was the garage built? Do you know, Mr. Hatt?
It was more recently than in the house.
Did the garage need a special permit when it was built?
I saw no history of special permits in the.
Because the garage doesn't meet the setbacks, correct?
No.
So how was it built?
The garage space is listed on the assessor's card for what that's worth.
Where the hell is the plans?
The garage space is listed, and it's saying the house was built in 1967.
I just wanted to go through.
But I don't know. Good question.
Yeah, it looks like if there's a plan that would show that the garage was built lead me to believe it was built in 2002, because there's a plan for a building permit, and the garage is sort of
right because it was a garage. You could have, what is it, a 10-foot setback in the back?
Yeah, it was an 11-foot. Yeah, it's 11 feet on the
They met the sidelines and the front setback.
So we think the garage was
right. You cut right off. I couldn't hear you.
The garage was relatively recent. Is that what we're saying?
Yeah, it looks to me that it was 1999 or 2002. That's what the plan sort of. I don't know, but that's what it sort of looks like.
That's what it looks like. Yes.
So Vern, you should know that. What would be the setback on? I should know it too. On the back line where the garage comes into that I believe it's 10 feet is what is allowed.
Okay.
It was 10 feet at the time.
And so it was fine then.
Right.
Yeah, it was fine. Yeah.
But now, what does this do if we give them a permit?
Trevor?
Can someone just say what happened in the last 30 seconds? Because my internet dropped out and I lost.
Okay. What we discovered in the last 30 seconds was that the garage was built in 2002.
Okay.
At a time when the setback for the garage was 10 feet, and so it met the setbacks.
Okay.
But and Manny's question was
The
In the
back
back,
of the,
yeah.
yeah.
Yeah, and
Yeah.
Manny's question is, what does this special permit do to that particular? It is a volumetric increase on the setback. We've already established that, so.
Right.
Yeah.
Well,
This is why you always get a lawyer to represent you.
I mean, I guess today would it be a legitimate question to ask if if there's a recreational room in the garage, does that change the setback to 25 feet?
No.
Would be 30 feet.
30, the back foot.
Sorry, it's 6.2 accessory building.
Mm-hmm.
No accessory building or structure except a shed, permitted sign, or a temporary roadside stand shall be located within a required front or side area setback or nearer to the rear lot line than 10 feet.
Okay, so it's not moving nearer than 10 feet. Okay. So it still meets that.
Yeah, because it's technically the rear, because the frontage is on Baker Avenue.
Right,
so
right.
It is 11. Yeah, so it
So
still
this
meets
is
the
technically
setback.
the rear, and therefore,
So frustrated.
yeah. Yep.
can Patricia Porter mute themselves because that's.
Yeah, there. I've muted her.
Thank you.
Yeah.
I have a question, Madam Chairperson. What conditions would Trevor like to see on this?
Yeah, that's a good question.
Well, I think the condition that it not be used as a, I don't know, some kind of condition that it not become an apartment or not become a, I mean, the only way they could do that legitimately would be to go through an affordable accessory.
Exactly.
Right.
So some sort of condition that prevents that. I mean, I agree with Manny that if they're going to upgrade the septic to accommodate it as a bedroom, and if the Board of Health isn't going to consider it a bedroom, then I suppose there's no reason they can't use it as a bedroom. But
they would
go
have
through this all the time.
They'd have to announce that, though, right? I mean, tonight they're applying for a special permit just for a game room, right?
Right.
Well,
I mean, we could say that it be used as the as a game room, as per the application.
Yeah, I'd be fine with that.
That would satisfy me.
Yeah. I mean, except, I mean,
although I think I would add, don't be subtle. If you don't want it to be used as a bedroom, don't be subtle about it. You know.
Okay.
So,
right,
don't
because
add anything.
The Board of Health is going to consider it a bedroom regardless of what.
Right. Exactly.
Madam Chairman?
Yes.
Again, I'm not voting on this, but I think by saying that it only be used as a game room, suppose somebody wants to use it as their pottery studio.
Yeah, exactly.
I think that's too limiting.
What the letter writer asked was that it not be used as living space.
right. So that's what we could do. You could say that the any space within the garage cannot be used as a bedroom, and no kitchen facilities shall be constructed therein. And then you've taken care of the whole structure.
It cannot be used as a domicile.
Right. Not be used. The space not be used as bedrooms, and no kitchen facilities be
right. That would
be constructed therein.
Right.
See, I just can't wrap my head around that.
I know.
I just, you pay good money to put and especially if you upgrade your septic system that really doesn't need to be upgraded. And then a board comes along and puts a condition on it that you can't.
Manny,
but Manny, we had the luxury of the applicant and the abutter are both agreeing to the same restriction.
Right.
So what the heck?
And Manny, this
because it drives me crazy every time I have to go through this.
Yes, but Manny, this 13,000 square foot lot already has a house with 3 bedrooms on it.
Yeah.
So I really don't. think the Board of
And
Health is making them put this septic system in for an additional bedroom. I think they're making them put this septic system in because they need a new septic system.
But can you guys just listen to me for just 1 sec?
Of course, Manny.
When you go to get a permit, you have to have a septic inspection.
Yes.
You pay to have a septic inspection. Now, if your septic fails, then you have to put in a new septic system. But what I'm saying is, if their septic system hasn't failed, they're putting in a new septic system because the Board of Health says, well, this is going to be a 4th bedroom. Who are we to tell them they can't sleep in it? Does anybody agree?
well, because they're asking something from us. They're asking for a special permit. And we could find that, no, it violates this, it violates that. We're not going to give it because there's too much activity going on the lot.
Right.
And therefore, we want to put the brakes on it a bit. You know? I mean, let's say you had a town sewer there. Then you wouldn't have any septic issues, right?
Right. You could do it by right.
But you might still turn it down because of the massing on that particular lot.
And Manny, you keep threatening to retire anyway soon.
I am
anyway,
not
you know?
retiring.
What's that?
I will not.
All right, so where are we here?
I was threatening to retire.
He does threaten to retire.
Right.
All right. Well, just Trevor, are you comfortable with those conditions? As you?
Yeah, I mean, I would want the condition to read that it not become an apartment, a living space. Not necessarily a bedroom. I mean, I agree with Manny that it's fine. You can sleep in your kitchen if you want to. You can sleep in any part of your house or your property.
Right.
So, but I'm more concerned that it's going to creep into an actual separate living space, not that. Yes. And I don't, we haven't really talked about the massing on the site, but I still, the contention that I first threw out there that there's, it's a small lot, and this is going to be quite a large building in a very dense little neighborhood. I don't know. I don't feel entirely comfortable with that myself. Perhaps nobody else agrees with me, but
I will move for findings.
All right. I need a second.
I'll second that then.
All right. I don't know who seconded. All right. This is what I have. Carol Tout, trustee, request for special permit to permit construction of a second floor to a pre-existing garage. The application is for a special permit to allow for the construction of a second floor to a pre-existing garage 24 by 32 feet, 24 feet by 32 feet, which is hereinafter referred to as the addition. The construction of the addition would not further increase the existing nonconformity of the setback requirements, 30 feet, but would result in a volumetric increase of 28.8% of the existing garage within the current footprint of the garage. The applicable provisions for this application under the Town of Wellfleet zoning bylaws are Section 5.4.2, front setback 30 feet in the R1 district, Section 6.1.5.b, and Section 8.4.2. Section 1.6.1.5.1b, the board finds that the alteration is not substantially more detrimental to the neighborhood than the existing non-conforming structure. Section 8.4.2.1, the board finds that the addition is suitable in that it is compatible with nearby land uses which would not be damaged by the addition. The board finds that the roads, drainage, and other public utilities would not be affected by the additions. The board finds that the addition will not contribute to environmental damage. Section 8.4.2.2, not applicable. Section 8.4.2.3, the board finds that the building and site design will not adversely affect scenic views from public ways or neighboring properties. And I should add, there was one letter in support of the application. Although that's a kind of a strange way to put that because I'm not sure that letter was actually in support or
Right.
It was
not,
support
but it was in support of the condition. Anything I should add to be adding to that?
I will move to accept the finding of fact.
Okay, and Mick seconds. All in favor, and my board is Will. Will?
Yes, sorry.
Trevor?
No.
Okay, you don't accept the findings?
No.
Okay. Manny?
Aye.
And Nick? And myself, aye. Okay, and then I have two conditions here on this one. The first one, this approval is conditioned on the property owner or its agents making all improvements and otherwise complying with all the matters set forth in the notes 1 through 16 exclusive on the plan entitled Septic System Upgrade Plan by JCLS Design dated June 5th, 2020. This condition must be satisfied within 1 year of the date of this approval, October 18th, 2020. And the second condition is that this addition not become an additional living space. Is that the way to put that?
And just put say, and maybe say, and no kitchen.
And
no kitchen facility shall be permitted, and that takes care of the it changing into an apartment.
Okay. Anything on?
I will move to grant the special permit.
Okay.
I'll second that.
All right. And all in favor, Will?
Aye.
Me? Aye. Trevor?
No.
Manny?
Aye.
And Mick?
Aye.
Okay, so this one also passes 4-1. All right. Thank you very much, people.
Thank you very much.
Okay. All right.
Oh.
Halfway there. All right. 2007 Starboard Tack Holdings Incorporated. Application for a special permit, etc., to alter a pre-existing non-conforming property in the commercial zoning district by demolishing the existing 2-story residential use building and constructing a 2-story mixed-use building. And the board is Will, Retha, Trevor, Janet, and myself. Ben, you're on.
Thank you, Sharon. Hello, everybody. It's nice to see everybody and hear from everybody. I'm here online, and I think Thorbaum and Meyer are probably online as well.
Yep,
I have a report. I have a report for the board, and then a request. The report is that I had what I consider to be a very productive discussion with the chairman of the planning board today. And there's bad news and good news. The bad news was that he doesn't see the ability to get his board to meet anytime in the foreseeable future. Some of the members don't want to meet virtually and are willing to meet outside, which doesn't really create a solution. But what he's willing to do is to circulate this application to the board members via email and assemble their comments and provide those comments unedited to this board so that it can hear from each of the members as to their comments on the application itself. So my request, and he thinks he can do that in fairly short order. So that was my report. My request is that we continue with one cycle to November 12th to allow Jerry to circulate this and get the comments back to this board. I do note that, and I saw, and if Chris is on the line, thank you, Chris Bates, for giving me the comments from the fire department, the police department, and the DPW. And I think those will be helpful to us. And I'm hopeful that by receiving those comments from the planning board, we can actually make a revision to the site plan and submit it to this board and have this application in a form that this board can have a substantive and meaningful discussion on the application, if not vote on it at the November 12th meeting. And that's the sum of my comments at this point. And thank you all.
So Ben, I hear you. And what apparently Jerry is saying is he wants to give us all his raw material and let us do his work for him. So I thank him for that.
Well, Sharon, I suggested that. That wasn't his suggestion. I was, Sharon, I was trying very hard to make sure that, the planning board understood what their role in this is. And their role is not to approve or disapprove this project. Their role is to provide this board with recommendations.
Right.
And so, in the absence of having a meeting and violating open meeting laws, I thought that providing the commentary to this board from the members would maybe be a little over-inclusive of information to this board, but it would be the fairest way to provide you with information from the board without them actually having a meeting. So.
Right, and I agree with that. I'm being somewhat sarcastic. But...
Oh, well, thank you for that. When it gets to a certain hour, it goes right over my head. So.
That's right. But, and I will let the board speak in a minute, but realistically, given that there are no curb cuts going to be allowed on Briar Lane, you need a new plan.
We do.
So you need not only the planning board, but you need time to redraw and resubmit. And I don't think a month is going to do that.
We'll take a longer continuous. I am so cognizant of this board's frustration with this application that I'm trying to keep it on as short a leash as I can. If this board was willing to go out to the December meeting and just shelve this until then, I would be ecstatic. But again, I'm sensitive to your frustration, but understanding that my client's frustration is probably equal to yours. So.
Right, I'm sure it is.
Yeah, can I?
Will.
Yeah, I mean, I would just like to see when you get a new plan. I mean, I'm just so curious that the first plan that was submitted, you're saying has mistakes of galactic proportion. You're 18 spaces short, and you say, no, that's not true. And it may well not be. But all I'm saying is, I certainly want to have a chance to look at a plan at my desk for a week or two before I'm going to vote on it. Mm-hmm. And
Understood.
So what I don't want to do is get a plan and then expect me to vote that same night. Yeah. So I don't know what your thinking is in terms of getting us the documentation we need.
I'm always cognizant of the fact, and I always strive to make sure that this board has information at least 1 week prior to your hearing date. That's what I understand to be, if not the written rule, the rule that we all operate under.
A week is fine too. A week is fine.
But I
exaggerate.
I think my clients and I have an idea, especially based on the comments from the DPW and the fire department and the police department, as to what changes we think we need to make to this plan and what arguments we need to present to this board. So I don't think it's going to be a surprise to us what comes from the planning board.
Yeah.
So but that being said, to get the planning board to have this meeting within the next 2 weeks, to give us a week to prepare a plan and have it filed a week ahead of time, would be a little tight for us. So that's why, the December meeting would be wonderful. But again, we're here on bended knee. So,
Manny?
I'm not on.
That's right, you're not on.
Okay.
Retha?
I think we need the time to examine the new ideas.
Trevor?
I don't see any reason why we can't continue this till December.
I don't either. Janet?
Okay. We keep continuing this, and I'm concerned about abutters who keep showing up at meetings, our Zoom meetings, and nothing happens. I'm also, I'm really frustrated with the planning board and that they're going to submit individual opinions without meeting together, without having a public hearing so people can make comments. Look how we changed our minds about Cumberland Farms, because everybody talked and we heard what everybody said, and we did a complete turnaround. I have a real problem with them doing that. And, call it prejudice because I used to be on the planning board, but I have a real problem with it.
I mean,
go ahead, Will. Yep.
Is the planning board doing anything, or have they just gone out of business?
They've gone out of business.
Yeah.
Well, that's ridiculous.
Yeah.
That's just plain ridiculous.
Yes.
Thank you, Will.
We're like a banana republic town, for crying out loud.
I mean, I'm not even sure, it doesn't even sound right for us to accept their opinions when they're not meeting and they're just avoiding a meeting.
I know. I see how Ben is getting around the open meeting law by not really having a meeting, but just getting opinions. But it certainly flies against the spirit, if not the actual law. I'm no expert on the open meeting law, but it certainly seems to violate the spirit of it, if not the legal part itself.
Well, let me throw something out for this board. Look, first of all, you know, the purpose of my call to Jerry was to determine what the timing was for the planning board to meet. And the answer was, there is no timing. There's no foreseeable meeting of this planning board. And you have to understand, we filed this application on March 11th of 2020, right?
Yeah.
Right.
We're under a demolition delay, but my clients have to, you know, look, once this board issues its permission, if it does, they still have to get financing. They have to get construction drawings done. They have to put building permit applications together. They have to comply with, look, it's not as if we have this unlimited amount of time for Thor and Maya to get this project going. And so
I understand.
These aren't theoretical problems. And so whether we withdraw this application and refile it, or whether it stays continued, it doesn't change the status of this application. So if I can't get this planning board to meet, then I think then what we're talking about is this board recognizing that the planning board is not going to provide guidance that it requested, and then it goes ahead and it makes its own decision on this application.
Right.
So if that's the case, you know, I think I know what we can do to this plan to at least address the concerns that have been properly expressed by DPW, fire, and police.
That's where I'm at right now. I think I liked Ben's idea when he first threw it out there. I thought, oh, that's nice, but I think Jan's point is spot on. That and if the planning board refuses to meet, then pardon my French, but screw them. We'll just move forward without their opinion. And if they don't like it, that's too bad. They didn't want to meet.
Well, if that's the case, we can go to the November meeting and we can have a plan into this board in 2 weeks.
Yeah, I think
Yeah, I have wanted the planning board's expertise, particularly on the parking. But partly I have wanted that planning board's expertise because I thought that it would also be a chance for abutters to come forward to the planning board to raise their issues. And that part of it is not going to happen because the planning board is not going to meet. So those abutters will have to come to us. So we might as well just move forward. But you have to.
I agree. Request the board to continue. So if the board's willing to entertain that, I would ask for a continuance to the November 12th with an eye towards having a public hearing on the 12th and considering the application.
Okay.
Not good to me.
Janet?
Yeah. Through you, Ben, I want the plans in our packet though. I don't want to see them online or, you know, in an email. I want them in our packet.
Right.
Absolutely. Our you know, with the exception of, I think, one that you have tonight, which we sent electronically, you know, my plan is to deliver the number of hard copies to the town hall so that they can be circulated to you all, as well as electronically.
Yeah. And also, Ben, if you're going to submit anything you're going to submit for us to review at the November meeting, I'd like it in that packet. So we've got the whole thing, not just the plan, but the whole, anything you want us to look at.
Absolutely.
Okay.
Could I jump in for a minute?
Yes, Chris, you can jump in.
Ben, if you'd be kind enough to send 3 additional copies of the site plan so I can give it to the police, the fire, and DPW.
Okay, so what is, Chris?
And have another review.
So you want 15 copies altogether?
Please.
Absolutely.
And Sharon, will the DPW and police and fire, they responded in writing, I assume?
They did, yes. They responded in writing. I can read you that letter. They
just email them to maybe Chris can email them.
They were at this point saying no, they were not going to allow additional curb cuts on Briar Lane. That was not something that would be. That was sort of the combined feeling of police, fire, and DPW. No curb cuts there. But they would get the new plan and react to that as well. Brad, do you have your hand up?
I do.
Oh, okay. Yes.
I would like to also request that the abutters have the same information so that we can know exactly what's going on. And I think that's important that we get that information and not have to rely on someone else telling us what it's all about.
Madam Chairwoman?
Yes.
What I can do, and Brad, hey Brad, what I can
do
is anybody who wants, if they wanted to send an email to Chris Bates if they want information, I can get that email list from Chris, and I will circulate to everybody who wants that information. I'll send the package out to them when we file it with the town.
Would that be good?
That's
Brad?
fine. As long as we get the information, that's all I care about.
Okay. All right. Good. Thank you, Ben. All right. All right. Anybody else? Anything else here?
Hi.
Yes.
Hi.
Hi.
Thor and Maya.
Yeah.
We don't want to waste any more of your time either. So
Sure.
based on the decisions by the town and the fire chief and the police chief, the plan we like to propose needs guidance. Do you understand what I'm saying? We don't want to bring a plan to you guys that doesn't make any sense. So what we are trying to figure out is what do we need to do? Do we not have any parking? We're not opposed to, we need guidance, basically. We don't want to waste your time. I don't want to bring a plan in front of you. We don't want to bring a plan in front of you that doesn't make sense.
It's dead on arrival. Yeah.
Can I address Thor?
Yes.
'Cause
Yes.
we've had this issue before, and I'll say what I'm going to say, and then tell you why. I don't believe we as a board can give you guidance because we've got abutters that may totally disagree with what you might propose. And so if we say to you, gee, if you do A, B, and C, we'll look favorably upon that. And then the abutters say, geez, Louise, you're working with the applicant. So it's really not. And so when I say we don't give advice, it's not because I'm pro or con. It's just, it puts us in a very difficult spot vis-a-vis people that might disagree with what you're proposing.
Okay,
You know, so
my question would be then, is there parameters that we have to fall under?
well, that's what Ben is there for.
Well, but also I think that, I mean, for example, here it's clear that you've got a no from the police, fire, and DPW. It might behoove you to talk to them.
Madam Chairwoman, I'll talk with Thor and Maya offline about this.
Yeah, because there are those kinds of places. I know we don't have a building inspector at the moment, which is part of the other thing, but yeah. Ben, you can give him some pointers on where to go.
We will talk.
Yeah.
The parameters they have to fall under are the zoning bylaws.
Right,
And
exactly.
if they can't meet the zoning bylaws, then they need to work with professionals, whether that's an engineer or a lawyer or someone who can advise them on how they can come close to meeting, as close as possible to meeting the bylaws, and then present us with an application that is as close as you can get, I guess.
Yeah, Madam Chairwoman, I think in the absence of a plan that we're asking you to approve, I don't think it's fair to the abutters to be discussing what is going to be in that plan.
Right, I agree. So,
Madam Chairman,
yes.
I have a question. So in the zoning bylaws, 6.3.13A, other uses, it says that parking requirements for all of the uses not specifically mentioned, and this use is not mentioned, shall be determined by the Board of Appeals for those uses controlled by special permit, yada, yada. So does that mean it's up to us to figure out what the number of spaces? Because this type of use is not listed in the zoning bylaws, and what criteria would we use for that? I'm kind of confused about that.
Yeah. Yeah.
Madam Chairwoman,
Yes.
I will be making arguments at the next hearing as to what I think the appropriate methodology is for looking at parking on the site, and why the number of spaces that we will propose is appropriate, and how the board can look at that. I think Janet's question is spot on. I think she's going right to the heart of what we're going to be dealing with.
Right. Okay. Anything else for this applicant?
Oh, yeah, well, otherwise, Ben, because I like to see things written down. And if you're going to present something verbally about the parking, I would really appreciate it if we had your argument in writing. Because I prefer, my mind doesn't work as well as it should verbally, but when I see stuff in writing, the synapses usually connect.
I think it's nice to see another self-deprecating member of the board. I miss Bruce a little bit. Well, I don't think you're losing anything off your fastball, but I think that what I will present with the plan is a narrative as to why we are requesting what we are requesting.
Thank you. Thank you.
Yeah. And this is a demolition and rebuild, yes?
Yes, it is.
So the other, just off the wall question, just so you can keep it in your head, is it looks to me like it's 31 feet high in the new building. And I'm not sure why.
I think Thor can address it. I don't think we're going any taller than the existing building.
No, we're actually shrinking it.
Okay. But it's 29 feet.
Well, if you have a building that's 31 feet, you can alter an existing non-conforming structure, even with a demolition and rebuild.
Even with a demolition?
Yeah. A demolition is still an alteration.
Okay.
Yeah.
All right. Okay. So I guess what I need is a move to continue to November 12th.
I so move.
And I need a second.
Second.
All in favor? Will?
Aye.
Retha?
Aye.
Trevor?
Aye.
Janet?
Aye.
And myself? Aye.
Thank you all.
That was November, right, Sharon?
November 12th, yes, to our next meeting. That one goes in a different pile. Okay. All right, 2014, Paul and Patricia McDavitt, 99 Holbrook Road, application for a special permit under Wellfleet zoning bylaw 6.1.5 to construct an open farmer's porch on the east side of the existing house within the front setback and to construct a deck off the rear.
Hello, everyone. I'm Paul McDavitt. I'm here with my wife, Tish. As you just mentioned, we're hoping to planning to build a farmer's porch on the front part of the house. We're going to be using AZEC built material for decking and the posts. It's going to be like a one-step raised porch with an overhanging roof. We also want to put a deck in the back. We're going to use similar materials, the AZEC building material as well. We want to use some cabling railing, and we're trying to build that in such a way to maintain the view corridors for our neighbors.
Oh, I did not set the board. The board for this is myself, Will, Nick, Aretha, and Janet.
And Trevor recuses himself.
And Trevor and Manny have recused themselves. Yes, sorry about that. Okay.
That's okay.
Back you go.
And, the other note I was going to say is I also have an application in with the conservation group. I've supplied them, I've furnished all the requested meeting information, and we're set to meet in a couple of weeks. We actually met yesterday, but I guess there was an agenda issue, so we got pushed to the next meeting. And that's essentially it.
Okay. Conservation. Okay. All right. Where am I going first? Will,
Yeah, I have a question for you. The proposed deck in the back, you increased the non-conformity from 10.4 to 5 feet. Now, is there a reason why you could not a deck be constructed, at least didn't further violate the setback requirement?
You talking on the driveway side, I think it's the north?
Yeah, it's the southern side. Because the setback now from the existing structure is 10.4, but the deck as constructed would be 5 feet.
You talking about the steps that lead up from onto the deck there?
Well, it shows that the deck itself, the corner of the deck is 5 feet. The steps are a little further to the east. I mean, the reason why I asked, we as a board have been very reluctant to further allow a further a intrusion into the setback. If you know you're grandfathered for the house, and that's certainly fine, but you're asking us to approve a greater setback than
Right, I mean,
it's already non-conforming, and you're asking us to lop off another 5 feet.
Yeah, the thinking there was essentially the bulkhead, which is right in front of that set of stairs, just made it an easier transition to get onto the steps, that's all.
Okay, thank you.
We were trying to keep pretty much that same line, like the kitchen set of stairs, we were trying to keep that same line to not go any farther than that.
Now, have your neighbors, do your neighbors know what you're planning on doing, and are they in agreement? Do you know?
I believe all our neighbors, I don't know of one neighbor because we've not met them yet. We only purchased the house back in May. And as far as I understand, our neighbors are in agreement. I've talked with Karen and Brad, who are our neighbors on the other side, and they're fine. And I mean, Trevor is one of my neighbors. I believe he's okay with it. And who's the neighbor we just met across the street? Yes. The gentleman right across the street, I can't recall his name right this second, but he came across yesterday and said hi and was happy to see that we were here and was all for, he didn't have any objections to what we were doing.
Okay, thank you.
Chris, did we have any letters on this? Chris?
No.
No. And is anyone in the audience here to speak to this particular project? No. Okay, Mick.
He fell asleep.
Mick, you're still muted.
You hear me now?
Yep, now I can hear.
No comment right now.
Okay. Right. Janet.
Help me out a little bit. I did view the property. On the site plan, the plot plan, there's a private way. As far as I can tell, that's a paper, that doesn't exist.
Right.
Right, paper road.
Okay, because the driveway goes into that. Is the entire property in the ACEC, the area of critical environmental concern? Is that correct?
Where we're putting the deck, that's yeah, we're outside the 100-foot, but we're still in the ECAC or whatever it's called.
I just wanted to make sure I'm reading this correctly. I don't have a problem with the front porch. I think that's going to look really nice. And the deck looks, I think it would probably look beautiful. I'm just a little concerned about the same thing Will said, that you're increasing, making a further intrusion into that setback by the driveway, by the private way. And boy, it's right on the edge of that. But that's not our problem. That is right on the edge of that slope. I guess I don't have any other questions, but I am concerned about that 5 foot going even another 5 feet into the setback on the side by the driveway. I understand why you did it design-wise.
Okay.
Rita?
I don't know. I have some issues with the deck, the proposed deck. The porch will be wonderful. I think that's really, really good. I kind of agree with Will that it does push it into a more unconforming property here.
Nick, was that the main thing, Rita, then?
Yes.
Yeah. Okay. Mick, did you want to come back in on this?
Yeah, I'm okay with it. I don't like increasing the non-conformity,
right.
But what they're proposing on the deck it's minimal. It really is minimus. It's not affecting anything. It's an open deck. It's not covered. I'm okay. I guess what I'm saying a long way around is I'm okay with the project, even though I'm uncomfortable with increasing the setback. But to me, it's so minimus. I'm okay with it.
Okay.
I see where it just that seems to me for a deck to cut the setback in half on the side seems unnecessary. I mean, I see sort of why that's designed, but I don't know why those stairs can't be around the corner and not cut that far into the setback. Again, I have no problem with the porch. I think the porch is fine. I don't have a problem with the deck per se. But, we try not to increase nonconformities on tiny lots. And
right.
So I'd kind of like to see that deck be even with the property rather than moving it over into the private way.
If you had the stairs running parallel, if you pull the steps in and ran parallel to the 45-degree angle and set the perimeter of the deck to that point instead, would that help?
Yeah, I mean, if the deck, you move that so that it's not increasing on that setback on that side, I don't think any of us would have a problem with it.
No.
Right, we'll just do that.
Yeah.
We'll just make it work. That's fine.
Mm-hmm.
So what we could do, because I agree with that.
Yeah.
We could continue this, and you could submit a new plan.
Yep. And then by then you'd have been to conservation, so we wouldn't have to condition you on conservation.
That would be lovely.
Mm.
Okay.
Yeah.
That's what we'll do then.
Okay. All right.
Okay.
Great. Thank you.
So,
we make a motion for continuance?
Yeah, I need a motion to continue.
I move that we continue this matter to the November hearing.
Does the November 12th meeting work for you, Mr. Porter? Does the November 12th meeting work for you?
Mr.
It works for me. Yeah, I'm not Mr. Porter. I'm Paul McDavid.
Oh, McDavid. Yes, I'm sorry. You've got.
We're jumping ahead.
Does that 12th date work for you?
Yep, that's fine.
Okay. All right.
I'll second that motion. So.
All right. And so all in favor, Will.
Aye.
Nick.
Aye.
Retha.
Aye.
Janet.
Aye.
And Sharon. Aye. Okay. So we'll continue that to November 12th. Thank you very much.
All right, thank you very much for your time.
Okay, thank you. Good luck with conservation.
Yeah, thanks.
Okay. 32nd Street. This is, the challenge is to see whether I can hang on to my agenda for the entire meeting, and I can't always. There it is. Yes. Charles Morris and Patricia Porter, 32nd Street, map 29, parcel 434. Special permit to alter pre-existing non-conforming residential dwelling by increasing The previously permitted 13 by 8 foot first floor bathroom addition by 2 feet to 13
Madam
by 10.
Chairperson,
Yes.
I'll recuse myself from this hearing.
Okay, so then the board will be Will, myself, Retha, Trevor, and Manny. Okay.
Madam Chairwoman,
Yes, sir.
again, this is Ben Zender, and it's still nice to see you all. This is a, well, it is, I'll revisit that at the end of the hearing, but this is an application to amend a prior special permit for Charlie Morris, who's also on the phone with us tonight. And in the designing of his project, the architect and he came up with a slight modification of their plan, which is shown on the plans that were filed with the application. You should have an amended floor plan, A2.00. And if you look, if the board members were to look at that plan, there is a bump out in the bathroom on the right-hand side of that plan that is 12 inches in width, meaning they're extending the bathroom out by 12 inches, and the bathroom is 13 feet wide. So it gives them a little bit more room in this bathroom. We've submitted a site plan and then a newer site plan that you received the other day that shows this area on the plan that's 24 inches by 13 feet. Mm-hmm. And it would be 26.1 feet from the property line, so it's fully conforming as to the setback. And I did the calculations as to lot coverage. This would bring the lot coverage for the property to 13.8%. So it would increase it from 13.5 to 13.8. So it would still be conforming as to lot coverage as well. I apologize for the plan. It's not re-stamped by the engineer. The problem was we couldn't get the engineer. We couldn't onboard an engineer to prepare these plans in time for us. It just wasn't possible. So the site plan is the old David Little site plan with the sketch of the new location, the expanded location. However, the architectural plan that's submitted to this board, that A 2.00 is an exact architectural plan of the proposed structure as amended to increase that 26 square feet of floor area. So that's really all I have to tell you. I'm hoping we can answer your questions and that Charlie can move ahead with this project. And thank you.
But Ben, as you know, we are considering this to be a new permit because it was expired. So we're just going to rule on it as the whole bathroom rather than as the.
However you want to do it, it's fine with me. Thank you,
know,
yeah,
because it did. So, where the addition goes is in the back or the side. What is considered front and back?
Yeah,
on
which
this
is the frontage?
Hold on. I think it's oriented towards Ridge Avenue. So I'm not sure about that.
I think 2nd Street must be front, so this bathroom must be back.
Yeah, I'm not sure. I'm not sure about that. So, but in any event, if it is the back avenue, then the existing structure is 27.3 feet off that rear line, so it's already pre-existing and non-conforming as to that. So the board would consider it an extension of non-conformity.
Right. That's what I thought it was. That's why I was asking.
Okay. Thank you.
Chris, do we have any letters on this one?
No.
No. And does anyone from the audience want to speak to this one? Nope. Okay. All right. So I will start wherever I put the thing with Manny.
Hello. I have no problems with this.
Thanks, man.
I know it's a little bit in the setback, but
yeah. Yep. Okay. Will?
I'm all set.
I have no problems with this application.
Okay. Trevor?
I have no problems with it, but I think we need to decide which side is the frontage so we can decide if we're talking about the rear setback or the side setback, because it makes one heck of a big difference whether it's a further intrusion into the rear or whether there's no intrusion at all if it's a side.
Isn't it where they get their mail?
Where's the front door? Can I? Where's the front door?
The front door faces northwest, so that's not really relevant.
But that's not the address. The address is 2nd Street.
Correct.
So then I think
Okay.
it's the back.
So it should be the back.
Yeah, it should be the back. What did we say?
Madam Chairwoman?
Yep.
I just went back and read the decision very quickly while you were asking this question, and the 2nd Street was considered to be the front yard.
Right. And I think we should maintain, even though we're hearing this as a new case, I think we set a precedent for ourselves, and we should maintain that 2nd Street is the frontage, in which case we're talking about a further intrusion into the rear setback.
Right.
Which
doesn't sit well.
Well, I don't know. I mean, I don't know if the board has recently talked about further intrusions into setbacks, but I think that we tend to not look favorably upon that.
Right.
Madam Chairman, if I may, it's because because that setback is already intruded upon. It's still a special permit. So, we have to demonstrate that it's not going to be substantially more detrimental than the existing structure. I'm not sure the board should be setting a policy about this as opposed to reviewing each one as it comes along. So this is going to extend further into that 30-foot setback by 24 inches. But I'm hoping the board will find that, at least this design and this neighborhood and this location, it's not going to be substantially more detrimental.
The strange thing about this one is that if you look in our packet at the 2012 decision, we appear to have created we created the intrusion into the rear setback. It was 35.2, and we allowed an office that went to 27, made it 27.3.
Sharon, I disagree.
Well, that's what our findings say.
No, the finding says the structure is non-conforming as to front yard setback being 11.7, rear yard setback being 27.3. The finding was that the existing structure was non-conforming at 27.3.
Yeah, but look at this. I'm just puzzled by this. I'm puzzled by this decision. It's our decision from 1205. And it says the proposed structure would reduce the rear yard setback from 35.2 feet to 27.3 feet.
Now, Sharon, if I may, looking at the plan that we've presented, the decision the proposed addition was really just, and you can see it on the plan, it says proposed addition. It was just filling in that side of the building. It wasn't going any closer, but the building was already 27.3 feet.
And no, I'm just puzzled by how it got to 27.3, which we seem to have created in 2012.
No.
No? I'd like to know the answer to that question. It's the decision signed by William Nicholson when we gave the permit to Cynthia Hope.
Right.
I'll have to read that very quickly.
Doesn't it say a rear yard setback being 27.3 feet?
It says, finding number 4, the proposed structure would reduce the rear yard setback from 35.2 feet to 27.3.
That's the office that was added.
Yeah, the office that was added.
So the
I don't know what we do with it. I just am fascinated by the fact that we managed to take an existing, and we just sort of willy-nilly created an intrusion into the setback there.
Thank you for that.
Well, yeah. That 27.5 is 2012, and that's not even 10 years. I ain't grandfathered.
I don't think it's unlawful. I mean, look,
no.
I still don't think there's a question as to whether the structure is lawful. It was built by a lawfully granted permit and a lawfully granted
It was. It's just I'm sorry. I just got fascinated by the fact that we just did that.
Right.
Mrs.
And
Plowey
Roger
would
was
like to comment on this, and I will let her comment. Hello.
I would if I could add something. I live next door.
Yes.
Sharon, I think that you're still having this problem with what is the front and what is the back.
Yes.
I think the decision in 2012 considered not where the front door is, what you're considering the front, where the front door is 22nd Street, but the side of the house, so that the office looked like it was in the back, but really it's on the side. It's all semantics. And truly, the house is oriented so that the part that's at the water is the back of the house. But I'm not sure that you're not looking at that as the side. And where the office went is the side of the house that comes toward my house. And so now the bathroom kitchen addition.
We then considered the rear at that point.
Exactly, you called it the rear, but it's now being called the side. So I have, I'm just saying, I think that's where your problem is.
Thank you, Jen. I think so too.
Our problems are much more deep-seated than that, probably.
More than likely. So, Trevor, this is all back to your point of what are we going to consider? If this is the side, it's meeting the setbacks.
No, but I disagree with Jan because we're not calling it the side. We're calling it the rear. We decided that Second Street is the frontage.
Right.
Therefore, this would be the rear.
Right.
So we're not calling it the side.
Right.
You're calling the side the rear. Okay.
Right. Okay. So, I mean, the address is 2nd Street.
Because it doesn't,
both prior permits.
zoning
Both
doesn't
prior permits
care
are called
how
the
you
rear.
orient your house. Zoning doesn't, zoning has a front setback, which is from the street. It doesn't care that if you then build your house turn the other way.
Right.
Sideways.
Okay.
Zoning doesn't care.
All right.
And there are no mailboxes on in our neighborhood at all. None. That wouldn't help. No.
You're lucky.
All right.
In our decision from 2017,
Yes. 17. Yep.
we said the front yard setback is 11.7 feet, which would mean Second Street is the frontage.
Right.
The rear setback is 27.3 feet, which is
That's where I was reading.
Okay, good. Yeah. Yeah. All right.
So this
And so-
proposal would increase the intrusion into the rear setback by 2 feet.
By 2
Right.
feet. Right.
Right.
Right. So,
And if I may, look, it'll give the Morrisons a slightly larger bathroom, which would be, it's not a big house. It would be very nice for them. So
and in the end, it would be, what would the rear setback be? 25? 25.3,
Yep.
where 30 is required.
Right.
We're conforming.
Right.
well, 26.1 is what we're showing on the plan.
I can't tell that you're showing that on the plan, but
Okay, the plan that we submitted, it says proposed cantilever 24 by 13, and then there's a set of arrows
yeah.
that say 26.1. And understanding that the building inspector is going to require an as-built foundation as well.
Right.
And a foundation plan as well.
Right. Right. Okay. Who haven't I been to here? Retha.
Well, it's 2 feet, right?
Yeah.
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 I don't know. I think
Not a big deal.
not a big deal. I mean, we went out and looked at it. We went and spent some time, checking it out. And it did not seem to me to be, something that could not should not be done.
Okay. Who else have I not called on?
Yeah.
Who else has not talked here? Jan, have you had a chance to speak on this one?
I have a question. I didn't go on the site visit with you. I went on my own, and I'm not sure, I got all twisted around there. I'm not sure I went to the right house now. Was there already a foundation poured? On the
Yes.
side?
Yes, there
Yes.
is.
So I was at the right, and then it was staked out 2 feet.
Yes.
So, okay, so there's already a foundation there. Is that foundation going to be removed? Is that?
No, I wasn't clear, Janet. I'm sorry. This is going to be cantilevered out over the foundation. It's not going. The foundation won't change.
All right, I understand. Thank you.
So it'll be essentially a 2-foot bump out over the foundation.
Over the foundation. Okay. Okay. Annie?
I have no problems with it.
Trevor?
I think we're all set.
Yeah, I've got a real problem with the math here.
Yes,
the
me too.
The existing building is 27.3 feet off the property line.
Yep.
Right? Correct? We all agree on that?
Yes. Yes.
They want to build a 2-foot addition.
Right.
Okay, 27.3 minus 2 is 25.3.
That's what I thought.
Right?
Right.
Where did they get 26.1 from?
It's scaled off the plan, Trevor. It wasn't done by an engineer. The building tilts away from that property line.
Yeah, I was gonna say.
The front
It's not square.
Yeah, it's not square to the building. So, I mean, we could come back with an engineer drawing, but if the board wants, but it's gonna. We're just we
6 inches.
Yeah. Who was that?
I don't know.
Wasn't me.
That was me, Mr. Morris.
Hello, Mr. Morris. Yes.
Hi, so you were saying the exact thing. There is a slight angle to the way the house was situated when we bought it, so that's why that number is not exact. There's like a 6-inch or maybe 4-inch differential.
But next time we need to know for sure.
Bob Asbro's built, exactly, yes.
Unless we need it now.
I was going to say, how do I, write it into the findings if I don't know what the math is?
Well, you can adjust the findings by just saying they can construct an additional 24 inch by 13 feet, and there it is.
Not give a specific number as to what the setback.
Right. Yeah. Don't give a specific number. And solve that problem.
All right. What I have right now says the proposal will increase the existing nonconformity on the rear setback by 2 feet.
That's not. I think that's fine.
That's good.
Okay. All right. Are there any other questions about this one?
Not I.
I will move for findings of fact.
All right. I need a second.
I'll second that.
Okay. All right. Here we go. The proposal is to alter a pre-existing non-conforming residential dwelling by adding a 13-foot by 10-foot bathroom addition. Is that math right?
Yes.
10 by 13.
10 by 13. 13 by 10 by 13. The lot's in the R1 district. The dwelling is
Sharon,
entitled.
I'm going to stop you. This is not a proposal to add a 10-foot by 13-foot addition.
Yes, it is, because it's a new
Oh, thank you. I'm
permit.
sorry. I wasn't thinking. I'm sorry. Thank you.
You're adding the additional, but you expired. This is a new permit.
Yeah, get out the red pencil. I stand corrected.
All right. The dwelling is entitled to treatment as a lawfully pre-existing non-conforming structure, having been in existence for at least 10 years, as provided for in Wellfleet zoning bylaw 8.2.2. The existing nonconformities regarding the structure. Now, here we go. Our inadequate lot area, 7,976 square feet, where 30,000 square feet is required. Intrusion into the front setback, 11.7, where 30 is required. Intrusion into the side setback, 20.5, where 25 is required. And intrusion into the rear setback, 27.3, where 30 is required, and inadequate frontage, 109.35, where 135 is required. The proposal will increase the existing nonconformity on the rear setback by 2 feet. The use conforms with the objectives of the R1 district. There were no appearances or correspondence in support of or in opposition to the application. Roads, drainage, and other public services are adequate for the project. The alteration will not be more substantially detrimental to the neighborhood than the existing nonconforming structure. And after considering the district objectives for the zoning district as provided for in Wellfleet Zoning Bylaw 3.2 and the relevant criteria set forth in Wellfleet Zoning Bylaw 8.4.2, the board finds that the benefits of the proposal will outweigh any adverse effects on the town and the vicinity.
I have a question.
Yes.
Is the proposed second floor deck also still being proposed?
No.
On the site plan, it says proposed second floor deck, or at least on the site plan where the addition is sketched on.
Is that the proposed cantilever?
No.
It's also on the updated site plan that Ben sent.
I believe it is. I'm going to let Charlie Morris chime in on that if you don't mind, Charlie.
Sure. Oh,
Now,
yeah.
that nothing has changed on the original plan that was approved except for this 22 feet by 13.
Okay.
Okay, because if they're planning to also build the second floor deck,
right,
then there's also a further intrusion into the side setback, the south side setback, of about a foot, which we did not mention in our findings.
No, we did not mention, and that's because of this confusion, because Ben's thinking of this as an amendment to the permit, but the permit expired, so this is not an amendment to the permit.
All right, so let me chime in here if I
Okay.
could. All right. In order to get by phase 1, we will eliminate any of the deck construction.
Uh-huh.
I will at another date, I will submit new plans for that we want to do for the deck that can be approved by the zoning board, and whatever in town. I'll have Ben do that.
Okay. I wasn't raising that issue because I had a problem with the deck. I just want the findings to reflect all of the changes that would take place. So if you're going to not do the deck, then I would actually request that you submit an updated site plan that doesn't show the deck.
Right.
Well, wait a minute. Let me say something. I'm trying to work with everybody. We want to do the deck, right? So I don't want to change anything. I thought you were suggesting that because the other one had expired, which I'm not sure because the dates we have for ours aren't the same dates you guys mentioned to us earlier, but everything else was going to stay the same. We were going to do one thing that was driven by the designers that work with my wife on the bathroom, that if we can get 24 inches, we can give her everything she wanted. That was all. Other than that, everything was going to stay the same.
Okay, that's fine. So then I think we should, I don't know if we need to discuss the second floor deck at all because we didn't even mention it, but at the very least, we need to include it in the findings because there's further intrusion into that section.
That would be good. Thank you.
We do, but the thing that I would like to have, which I do not seem to have, is the findings from 2017.
They're in the packet.
I don't, why am I not seeing them? All I'm finding is that 2012 one.
No, you should have one for 2018.
I think it was 2018.
Let me see.
They're the last 3 pages of the original packet.
All right. Okay, here we go. All right. So in that event, okay, I finally found them. So what we need to incorporate into these findings is the findings here that speak to the deck.
Right. Finding 5 and finding 6.
Finding 5 and finding 6. But it no longer does maintain the front and rear yard setbacks. The proposed alteration will decrease the maintain the front yard setback and will decrease the southerly setback and the rear yard.
That is still true, Sharon.
Yeah.
That point is not changing.
Well, but the finding 6 says the proposed alteration will maintain the front and rear yard setbacks, but we are in fact
We're not
changing.
maintaining the rear anymore.
We're not maintaining the rear. Because
Doesn't
now we're going further into the setback there.
Correct.
Yeah. I think you can say that it will maintain the front yard setback and will decrease the southerly sideline setback from 20.3 to 19.5. That's true.
Yes.
And then an additional finding will be it will
be this
decrease the
additional one,
rear
yeah.
yard. It will decrease the rear yard setback from 27.3 feet to 24 inches.
Okay. All right.
Or you can say we'll decrease the rear yard setback.
Yes, we're not giving a specific number on the rear because we don't really have it. We're just saying it's decreasing it
by 2 feet.
Increasing it by 24.
Yep. Yep.
Thank you.
Yep. And we don't have the new calculation for the lot coverage, or do we?
I did the calculations. I can present them to the board, but they're not on the plan.
Okay. Just tell me what it is.
Well, if we're doing it, the new lot coverage will be 13.8%. It will be 1,1102 square feet of building.
Give me again. We'll increase the lot coverage by how many square feet?
Okay, so we're going from the original decision. So it's going to increase it from hold on one second. Let me just see where this is. 2-story.
We said it was 973 in 2017.
Yeah, so in 2017 it was going to increase by 103. So it's going to increase it by 129.
129.
I'm sorry, 127. It's going from 103 plus 24 to 127.
127, yeah.
And the percentage of lot coverage will increase from 12.2% to 13.8%.
13.8, okay. Which is still under maximum coverage, yep.
Yes.
Okay. Good catch, Trevor. So, right, that stays the same. That stays the same. Okay. Does that work if I include those two aspects of the findings?
Well, I think so, but would it I hate to waste everyone's time, but could we maybe just read the findings again?
Yes. I will skip all the really, yeah.
That's fine.
I will skip the things like lawfully pre-existing.
Read the salient ones.
Right, okay. So I think the existing nonconformities have stayed the same. The proposal will increase the existing nonconformity on the rear setback by 2 feet. The applicant proposes constructing an 8 by 13 foot this is different. A 10 by
10 by 13.
10 by 13. The applicant proposes constructing a 10 by 13 first floor addition on the west side of the dwelling and extending the south side second floor deck to wrap around the top of the addition. The proposed alteration will maintain the front setback and will decrease the southerly sideline setback from 20.3 feet to 19.5 feet. The proposal will increase the existing nonconformity on the rear setback by 2 feet.
Yes.
The proposed alteration will increase lot coverage by 127 square feet to a total of, I don't have that math.
Ben gave you that at 13 something.
Yeah. No, that's the percentage.
To 1,102 square feet.
1,100 and.
Sorry.
100. I'm not sure that number's right, but at any rate, I can do the math on that one. It's 973 plus 127. $1,100.
Yeah, you're right, Sharon.
1,100
it is.
square feet. And the percentage of lot coverage from 12.2% to 13.8%, still under the maximum lot coverage of 15%. And then I'm not going into, then I go into roads, drainage, and so forth.
That all sounds correct now, Sharon.
Okay, good. So that's this one, and this one. Yep. All right. Good. All right. And that way we don't have to hear this proposal again.
I will move to accept the finding of facts.
All right. I need a second.
Second.
I second.
Okay. Retha seconded. All in favor. And I think I've, somewhere in the course of this, I lost the list of the board, but if you weren't on this board, just tell me. Retha.
Yay.
Will.
Yes.
Trevor.
Yes.
Manny.
Yes.
And myself. Yes. Okay.
I'll move to grant the special permit.
Okay. I need a second.
Second.
Okay. All in favor. Retha.
Yes.
Will.
Yes.
Trevor.
Yes.
Manny.
Yes.
Myself. Aye. Okay. I will clean up those findings, Chris. That may take me a little longer than some of the others, but you will have them.
You have been working hard.
Thank you all for staying so late tonight.
What time is it? Oh, time flies when you're having fun. We do have minutes.
Nice work, Sharon. I'm going to sign off. Thank you all.
Bye, Ben.
All right,
Hi.
guys.
Hi. Thank you. Bye-bye.
Thank you all.
Yep.
Thank you, everybody.
Thank you.
All right.
Goodbye. Bye. Porters. We do have minutes from October, such as they were. I need a motion.
I'll move that we approve the minutes.
Okay, I need a second.
I'll second it.
Okay, all in favor. Will.
Aye.
Manny.
Aye.
Nick.
Jan was good.
Dan.
Aye.
She was
Trevor.
factual saying, hey, you guys are screwing it up.
And Aretha. Somebody's got to be muted here. Yeah. And myself. Aye. I think that's it, guys.
All right.
I need
Have a good night.
I need a motion to adjourn.
I make a motion to adjourn.
Good girl.
Second.
All right. Yeah. And I'm not going to do a roll call on that. All in favor?
Good night.
All right. Good night, all.
Night, all.
Good night.
Thank you.
Bye.
Alrighty.
Bye.
Bye-bye.
Long meeting.
Chris, I will look at these in the morning.
Yeah.
I'm not
that would
going to
be
try to.
good.
I'm not going to try to clean these up now.
No.
I'm not Bruce doing this in the middle of the night. I will send them all in the morning.
Well, take your time.
Yes. Yep. And
You did all the findings, didn't you, tonight?
no, Will did findings and on 2 of the cases and then sent them to me. So I have I have them all to send to you, but I did not do them all. And Carolyn will get you the stuff
Yes.
on the on Cumberland Farms.
Very good.
So
Thank you for all your work.
thank you, everybody. Good night. Rita.
Tonight was a challenge, but we got it.
Yeah, we got it. We got it done. And with any luck, we only continued 2 of them to.
Yeah, not bad.
Not bad. Not
Okay, I'm
bad.
gonna end it.
Okay, very good.
Okay.
Bye-bye.
I know.
Bye-bye, everybody. Mhm.